Dr. Pecinovsky, you've received the Brian Bercusson Award for your PhD thesis on EU economic governance and the right to collective bargaining. Can you tell me the main points of your research?
My PhD mainly looked at two different aspects. At one side, the economic governance, which is the European semester. It's a sort of framework of instruments that the EU uses to give recommendations to the member states. It's not legislation, so it's not hard law, it's more soft law. And they give these recommendations to the member states that they have to try to follow. It's a monitoring cycle, so they will have to submit a report on what things they did to follow these recommendations, the measures they took, and then the next year they can get other recommendations. It's a sort of cycle. This is a very complex system which I described in my thesis, in my PhD. And at the other side, I looked at the right to collective bargaining, which is a fundamental right in Europe. And I have looked at the different legal orders where the member states of the European Union have to listen to or have to abide to. And in order to have a sort of framework, a normative framework to see if there were restrictions on this right, I distilled 22 indicators of this right to collective bargaining, so the 22 main elements of this right to see when are we talking about reductions or restrictions of this right to collective bargaining. So those are the two important sides of my research.
Thanks a lot, that's very interesting. So why and how problematic is the relationship between EU governance and the collective bargaining fundamental right?
That's when the two sides of my PhD come together, so the two parts of the research. First, I look at European semester, on country-specific recommendations, and on extreme economic governance. What is this? I really describe it. And then I look at the right to collective bargaining. In the later parts of the PhD, those two aspects come together, and I really look at the impact that the recommendations of the Commission had on collective bargaining and on the social dialogue in the member states. I look at several countries, to Belgium, the Netherlands, France, Italy, Sweden, Portugal, Spain and Greece, to see which recommendations did they receive over the past years. And often these recommendations were on collective bargaining, on, for example, the wage formation system. In a lot of countries, the social partners are involved in the wage formation. Often the recommendations were about, please change this system, maybe set aside the social partners in this system, so it had an impact on their right to collective bargaining about the wages. And second, a lot of recommendations were on decentralization of collective bargaining systems. So the EU was long convinced that collective bargaining on company level was better than on central level or sectoral level. So they always said, please decentralize your collective bargaining system because it's better. It will align your wage formation and your collective bargaining with productivity, with the companies itself. That this also, of course, has a deep impact on the right to collective bargaining, because according to this right, the social partners should choose themselves the level on which the collective bargaining should take place. And if you're going to force them to take a certain level, the lower level, where, by the way, the social partners are the weakest or the trade unions are the weakest, then this has a severe impact on the right to collective bargaining. Now, what was the impact? Mostly for countries which had a lot of problems with their budget, which were in a strong monitoring cycle of the EU, they were really forced to take measures, not only budgetary measures, but also measures in social policy and towards collective bargaining. And so this happened in most of the countries I named before. Some of these measures that they took were clear violations of the right to collective bargaining. So the measures were taken by the member states, but the measures were also recommended to them with a little force by the EU Commission and the Council.
In your thesis, you actually make some concrete policy recommendations. Can you just explain what these are?
Well, as I said, I made 22 indicators of the right to collective bargaining. So my most important recommendations is for the EU institutions, when they draw up the country-specific recommendations, well, they should look at these indicators and see, well, is what we are recommending to the member states now, the measures that we want them to take, are they not infringing on one of these elements of the right to collective bargaining? And if so, can it be justified? Is it a justified restriction of that right or not? So that's a sort of prior test of these indicators to see if it's allowed or not. Second recommendation is also, after the countries did the measures and the EU has to monitor what they have done, they also should do a sort of ex post test to see, again, with the indicators, well, is what the member states have done, or the measures they took, is this okay in light of the right to collective bargaining, and okay with all those indicators, was this not a violation of that right? So they should take more into consideration the right to collective bargaining when drawing up the country-specific recommendations and when implementing the country-specific recommendations. Next to that, there are some problems with the EU access to justice with regard to country-specific recommendations and economic governance, because it's not legislation, it's just soft law or hybrid law recommendations, and it's really hard to go to the Court of Justice if you get a recommendation that you think is a violation of the right to collective bargaining. So it should be easier for trade unions to say, oh, wait a minute, this is problematic. For now, this is really hard, and especially if we talk about extreme economic governance, and extreme economic governance, we're talking about the European Stability Mechanism, when they saved Greece the last time, Cyprus. Those countries get a lot of measures, and the sanction if they don't do those measures is bankruptcy. But this mechanism of measures that they have to take is completely, for now, outside the EU legal order, and it's not sure if the Court of Justice will accept cases if you go, if the trade unions would claim that this is a violation of the right to collective bargaining. There is some movements in the case law that might allow this, but it's really not certain. So I think the access to justice with regards to these violations or restrictions of the right should definitely be better. And then my last recommendation is, well, you have the right to collective bargaining. It's in the EU legal order, it's in the member states' legal orders, in their constitutions, etc. But it's also part of the ILO, the International Labour Organization, and it's also part of the European Convention of Human Rights and the European Charter of the European Social Charter. So there are different legal orders, and the EU can give measures that might go against the right to collective bargaining, which makes that the member states are also not abiding to their obligation to respect the rights towards the other legal orders outside of the EU. So this could be a sort of struggle between the different legal orders, which is highly problematic, because who do you have to follow? Do you have to follow the European Convention? Do you have to follow the EU? This is, of course, very confusing for the member states, and that's why I recommend that there's a sort of judicial or legal communication between the different legal orders, so they could avoid these sort of conflicts, incoherences between the interpretation of fundamental social rights, like the right to collective bargaining.
So thank you very much, Dr. Pieter Pecinovsky, winner of the 2019 Brian Bercusson Award. Thank you.